In this exchange between Senator John Kennedy and Pam Bondi, the conversation shines a harsh light on the potential overreach of the Department of Justice when it comes to the private communications of sitting U.S. senators. Through a series of hypotheticals, the discussion exposes the extraordinary legal and ethical hurdles that should protect lawmakers from arbitrary scrutiny. At its core, the dialogue raises critical questions about accountability, civil liberties, and the rule of law.
Let's suppose that I'm appointed special counsel at the Department of Justice, and I go to the telecommunication companies, the phone company, I single out AT&T, and I say, look, I know you're busy, but I want to see a copy of the phone records of a sitting United States senator. They're not going to just give them to me, are they?
No, Senator, of course not.
In fact, they're probably going to ask me what planet I just parachuted in from, aren't they?
Yes, Senator.
They're going to tell me to come back with a subpoena, aren't they?
Yes, Senator.
Okay. What do I have to show in that subpoena to get those phone records of a sitting? Did I mention it was a sitting United States senator? I can't remember. What do I have to show to get the phone records of a sitting United States senator?
Yes, Senator, there were actually 8 sitting United States
Yeah, I
senators,
heard that.
and you would have to have cause.
I'm sorry, what do I have to show?
You would have to have cause to get the
Good
subpoena.
cause or probable cause?
Probable cause.
Okay. Probable cause, or if it's a subpoena duces tecum, good cause, to show what?
You would need good cause for a subpoena duces tecum, and what you would have to show is that you believed a crime had been committed, or there was a possibility of a crime, or that could lead to other crimes. We frequently, in criminal enterprises, subpoena cell phones.
By the sitting United States senator?
Senator, they would have to have believed you were part of a criminal conspiracy, is my understanding.
Would a judge have to sign off on it, on the subpoena?
Yes, Senator. Well, for a subpoena duces tecum, Jack Smith probably took it straight to the judge.
Now, the phone companies, particularly their general counsel, if they're worried about civil liability, even with a subpoena to get the phone records of a sitting United States senator. Did I mention it was a sitting United States senator?
Yes, Senator.
The general counsel for that phone company, let's say AT&T, they have the right to seek to quash that subpoena, don't they?
Phone companies frequently do that.
And a smart general counsel for that phone company is going to call the sitting United States senator and say, would you like to weigh in on this? Would you like me to quash the subpoena? We're talking about invading someone's privacy here by a sitting United States senator. Could the general counsel for the phone company do that?
Well, Senator, if they believe that a crime could have been committed, they could not tip off the person who committed the crime. Again, I can't comment on details of this particular case.
I'm just asking you theoretically.
I've never seen you commit a crime, Senator Kennedy.
But let's suppose, okay, they didn't want to tip off the sitting United States senator, but the phone company and the general counsel for the phone company, or companies, if there were more than one involved, could say, this is serious as an aneurysm. This is serious as 4 heart attacks and a stroke. This is a sitting United States senator. So general counsel would likely advise the CEO, you need to file a motion to quash. The telephone companies could have contested those subpoenas, could they not?
Hypothetically, yes. I can't talk about the facts of this particular case.
We're talking hypothetical.
Senator, subpoenas are issued all the time through phone companies working with the general counsel.
But they can file a motion to quash.
They could, yes.
Yeah.
In any case.
And if they should have filed a motion to quash, and a reasonable person would have filed a motion to quash, because this is a sitting United States senator, and they didn't file a motion to quash, they would incur civil liability, wouldn't they?
Senator, typically phone companies follow a subpoena from a United States
I know they
attorney.
do, but they don't have to.
They could challenge it, Senator.
Yeah. And if they don't challenge it, They better have a damn good reason.
The Senate exchange regarding Cash Patel underscores profound concerns about the politicization of the FBI and the erosion of institutional independence. From a progressive standpoint, the discussion about Patel's so-called enemies list is particularly alarming. Even as he denies its existence, the documented adverse actions taken against roughly 20 of the 60 individuals allegedly on that list within 7 months suggest a systematic targeting of career officials, raising questions about the criteria used to evaluate performance and the motivations behind terminations. A liberal analysis that federal law enforcement should operate based on merit, constitutional duty, and evidence, not personal or political loyalty to the director or administration. The very notion that employees might be evaluated or removed based on perceived alignment with a political figure fundamentally undermines the impartiality of the Bureau and sets a dangerous precedent for the weapon law enforcement. The exchange also illuminates deeper structural issues within oversight and accountability mechanisms. When Patel invoked grand jury secrecy and the supposed constraints of court orders to just holding information, it exemplifies how procedural arguments can be used to avoid substantive scrutiny. Judge Berg's clarification that Federal Rule of Criminal Procedure 6E allowed Patel to release his testimony highlights a discrepancy between legal realities and administrative practices, raising the question of whether procedural technicalities were deployed strategically to shield politically sensitive decisions. Progressives would argue that this points to a pattern in which oversight is circumvented, even when career officials to adhere to strict transparency standards. It reinforces the need for robust congressional and institutional oversight to ensure that political appointees cannot exploit legal interpretations to mask actions that compromise fairness or integrity. The discussion of the Jeanine Pirro background investigation further illustrates the risks of political influence on career processes. According to the transcript, Fox News executives characterized Pirro as reckless, untrustworthy, and prone to conspiracy theories, yet the committee remains uncertain whether the FBI's background checks uncovered and communicated these findings, or if political considerations allowed her nomination to proceed regardless. From a progressive perspective, this situation highlights a systemic vulnerability. Career investigators can be bypassed or ignored in favor of political expediency, undermining public confidence in the professionalism and objectivity of the Bureau. When personnel evaluations or background checks are influenced, even indirectly, by partisan interests, the integrity of federal appointments and law enforcement is jeopardized. Moreover, Patel's reliance on procedural deflection, asserting that career professionals independently adjudicate background investigations, or that he cannot comment on ongoing inquiries, while legally defensible, sidesteps the ethical and democratic expectations of accountability. Progressives emphasize oversight is not merely to adhere to the letter of law, but to ensure the spirit of impartiality, transparency, and justice is upheld. In a functioning democracy, federal law enforcement officials must be insulated from political pressures, and decisions must be communicated openly to the public and Congress. Anything short of this fosters suspicion, erodes trust, and risks allowing partisan priorities to dictate outcomes in ways that liberties and the rule of law. This exchange also exposes the broader societal consequences of such politicization. When the public perceives that loyalty to a political figure supersedes commitment to the Constitution, confidence in institutions like the FBI diminishes. Citizens rely on law enforcement agencies to act independently, fairly, and consistently. Undermining these principles encourages racism, reduces cooperation with authorities, and deepens political polarization. Patel's testimony, coupled with reports of targeted adverse actions, underscores the critical importance of maintaining career professionalism, protecting whistleblowers, and ensuring that political appointees cannot weaponize agencies for partisan gain. From a progressive lens, the Senate hearing is a stark reminder that safeguarding democratic institutions requires vigilance, accountability, and commitment to meritocracy over political loyalty. The integrity of the FBI, and by extension, the broader justice system, depends on these principles being actively upheld.